Medical cannabis housing rights. Virginia law is one of the most misunderstood areas of cannabis policy in the Commonwealth. Many Virginians assume that holding a medical cannabis certification automatically creates housing protections. That assumption can carry serious legal consequences. Today, we are going to slow this conversation down, examine what Virginia law actually says, and explain where the legal boundaries are right now. Here's the context. Virginia's cannabis framework continues to evolve, but housing law has not kept pace with public perception. Medical cannabis is legal under state law, yet landlords retain broad authority over what happens on their private property. This tension between medical access and property rights has created confusion for tenants, landlords, housing advocates, and even local officials across Norfolk and the broader Hampton Roads region. Understanding medical cannabis housing rights. Virginia law requires separating policy debates from enforceable law. Here's the legal explanation. Under current Virginia law, property owners and landlords are explicitly permitted to prohibit the use, possession, transfer, or cultivation of cannabis on their premises. This applies to both adult use and medical cannabis. There is no statute that compels a private landlord to allow cannabis use simply because a tenant holds a medical cannabis certification. Federal law further complicates this issue. Cannabis remains illegal under federal law. As a result, federally assisted housing such as HUD properties, Section 8 housing, and other federally subsidized programs prohibit cannabis use regardless of state legality. Virginia's fair housing law does not classify cannabis use as a protected disability. Because cannabis is still considered a federally controlled substance, landlords are not legally required to provide a reasonable accommodation that would violate lease terms. Lease agreements remain the controlling document. A standard no-smoking clause almost always includes cannabis smoke. Violating that clause can still serve as grounds for eviction. Medical cannabis housing rights. Virginia law therefore prioritizes property rights over patient access in housing contexts. Let's look at some alternative accommodations. While landlords are not required to allow cannabis use, they may still be required to engage in an interactive process. This means discussing whether non-smoking alternatives could address a tenant's medical needs without violating lease terms. These discussions do not guarantee approval. They simply require good faith communication. No Virginia law forces a landlord to accept tinctures, edibles, or vaporization if the lease prohibits cannabis entirely. Who this affects? This legal framework affects medical cannabis patients, renters, landlords, property managers, housing authorities, and local enforcement agencies. In cities like Norfolk, where rental density is high and mixed housing types are common, misunderstandings can escalate quickly into eviction notices or legal disputes. Medical providers are often surprised to learn that issuing a certification does not create housing protections. Why this matters? Housing stability is foundational. Misunderstanding medical cannabis housing rights. Virginia law can lead tenants to unintentionally violate leases, risking eviction or loss of housing assistance. For landlords, inconsistent enforcement or unclear lease language can expose them to disputes or claims of unequal treatment. Clear understanding protects both sides. Here's a real-life scenario. Imagine a Norfolk tenant with a valid medical cannabis certification who assumes state legality overrides their lease. They use cannabis in their apartment, believing medical status offers protection. The landlord enforces a no-smoking clause and issues a lease violation. The tenant challenges the notice, only to discover that Virginia law supports the landlord's position. This scenario is not hypothetical. It reflects current enforcement realities. There is ongoing legislative debate. As of early 2026, legislative focus remains centered on creating a regulated adult-use retail market. Discussions around housing protections have not resulted in passed legislation. A proposed bill addressing terminally ill patients in medical facilities suggests a growing conversation about patient rights in limited contexts. However, no tenant protection mandates exist for private housing. Medical cannabis housing rights. Virginia law remains unchanged in this area. What to watch next? Future developments may include court challenges, local housing authority policy changes, or narrowly tailored medical accommodations in institutional settings. Understanding how courts interpret lease enforcement and reasonable accommodation claims will be critical. Question: should Virginia law draw a clearer line between medical necessity and private property rights in housing? Put your answer in the comments. Thoughtful, respectful discussion is encouraged. Please like, comment, and subscribe for more Virginia-focused legal analysis like this.